Welcome everybody, and thank you for joining me for employment law training today. My name is Maggie Davis, and I serve as the Vice President of Human Resources for our company XYZ Corporation. We have a lot to cover this afternoon, so let's get started. We're going to cover quite a bit this afternoon, so please be sure to take notes as this information will provide you with an overview of how to keep yourself and our company out of trouble when it comes to employment law. We will discuss various topics to include equal employment opportunity, performance management, labor relations, and safety. Everyone has our employee manual with them today, which covers these topics as well. As we discuss these different laws and how they will affect you as a manager in our company, it's important to first discuss our company structure. As you all know, we're based and privately held here in Omaha, Nebraska, with one location which services customers in all 50 states. Most of our employees are on the production floor in a manufacturing environment. Most of you are here today because you are in a management role and need to understand the legal environment in today's workforce. While we strive to maintain a positive and employee-centric workplace, we must also work together to ensure we are compliant with all federal employment laws. As a manager, you'll need to know how these laws can and will apply to you and our company. Please understand, everyone, you can be personally accountable for certain violations of our company's policies and federal laws. As your VP of HR, my job today is not to scare you, but to help you understand how to protect yourself, our company, and your team members' equal opportunity rights, as well as their safety. One of the most critical components to training today is understanding equal employment opportunity. If you're not familiar with Equal Employment Opportunity, or EEO, this is enforced by the Equal Employment Opportunity Commission, which is a federal agency that enforces all United States labor laws, with the exception of the Equal Pay Act. I won't bore you with the legal definitions, but the most important thing for you to understand is this. Employment decisions, whether regarding hiring, job assignments, pay, promotions, discipline, or discharges must never be based on race, color, religion, sex, including pregnancy, national origin, age, disability, or genetic information. For the purpose of training today, we'll refer to these as the protected classes. You might be asking yourself how this applies to you. As a manager here, you are responsible for interviewing, managing, and terminating employees. That means you're required by law, as well as our company policy, to do so without discrimination. This includes employees who are resident aliens with eligibility to work in the United States. As an XYZ employee, you were and are afforded these same equal opportunity rights and will be held accountable for enforcing these traditions and policies within your teams. The most common lawsuits against organizations are filed with the EEOC, so it is vital and imperative that you understand what your role is in preventing. Now let's narrow in on the law and act that supports equal employment opportunity. Title VII, which is the Civil Rights Act, was signed into law by Lyndon Johnson in 1964 and outlawed discrimination based on anything defined as a protected class. This law also ended unequal voting rights and racial segregation in schools, at the workplace, and other facilities that served the general public. Many of you are responsible for hiring associates to your respective teams. Our HR department has outlined your hiring practices and has provided you with applications to use for employment. You'll notice, though, in the suggested interview questions that criteria related to anything belonging in the protected classes has been left out. As you discuss the position, please follow the policy of XYZ Corporation and avoid asking questions regarding race, color, religion, sex, national origin, age, disability, or genetic information. A really common mistake in the interview process is asking a candidate if they have children. It's a societal norm that is often asked in casual conversation. However, asking this during an interview might bias your opinion on a candidate's gender if the candidate is female. You might be quick to judge her availability for overnight hours. This is just one example, however. We should never ask someone if they have children or really anything that doesn't pertain to the actual job responsibility. The better question to ask is, what hours are you available to work? The do's and don'ts of interview questions can be difficult to remember, So to help you with mitigating your risk, please follow the interview guidelines as provided by my team in HR. Upon hiring an associate, keep in mind their pay should be equitable regardless of gender. Please seek the advice of HR when determining appropriate compensation offerings. The Equal Pay Act is a federally mandated law that requires you to pay equally for equal work. As you assign work, please do not discriminate based on this criteria as well. All employees here are to be treated equally and given reasonable accommodation as necessary and required by our company policy and law. The same applies for any punishment or terminations. When in doubt, you can also visit our company handbook, which outlines these policies more carefully. After our training today, you'll all be required to sign our employee handbook as well, stating that you are aware of and will comply with these policies. Harassment is also covered under Title VII and is strictly prohibited within XYZ. Our policy of harassment includes any unwelcome conduct that is based on the protected class criteria. Unwelcome sexual advances constitute sexual harassment and are also strictly prohibited. It's easy to establish rapport with your peers and subordinates, but never assume that anyone is comfortable with harassment at any level. Different examples of this would be avoiding offensive jokes, slurs, name-calling, obviously physical threats, assault, intimidation, offensive pictures, and also emails. As a manager, you are responsible for enforcing this policy within your team. Do not accept and report any conduct that is in violation. When a situation is reported, any retaliation to employees that have complained about any sort of harassment is also strictly prohibited. That person is not to be made an outcast or made fun of in any way. Switching gears now and taking a look at the Americans with Disabilities Act, or ADA, we will discuss how our company enforces this and prohibits discrimination against people with disabilities in employment. Since we have 15 or more employees, XYZ Corporation is prohibited from discriminating against people with disabilities by Title I of the ADA. This means that we are required to provide equal opportunity in selecting, testing, and hiring qualified candidates with disabilities. Additionally, we will provide job accommodation for workers with disabilities when such accommodations do not impose undue hardship upon our company. A great example for you to remember is that although an applicant has an obvious disability, such as being in a wheelchair, you should not ask them questions around their actual disability. The application states very clearly what the physical requirements are of the jobs we hire for and will help you determine if someone is a suitable candidate. Since we are in a manufacturing environment, there are certain limitations as to what we can accommodate, but the general rule of thumb here is to not ask any questions about disabilities during your interviews. This could be used against you and our company in a court of law. If we discriminate against someone based upon this, you would be in violation of the EEO laws. Once a person is hired into our company, any employment decisions about job placement or otherwise are to be made without discrimination on this basis as well. Occasionally, life situations happen where our employees will need to take significant time off. Certain situations are covered under the Family Medical Leave Act, or FMLA, and require us as a company to allow employees to take unpaid leave. FMLA entitles our eligible employees to take unpaid, job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave at all. If you are not familiar with what qualifies as specified family or medical reasons, these are 12 work weeks of leave in a 12-month period under situations such as the birth of a child and to care for the newborn child within 1 year of birth, the placement with the employee of a child for adoption or foster care, and to care for the newly placed child within 1 year of placement, to care for an employee's spouse, child, or parent who has a serious health condition, a serious health condition that makes the employee unable to perform the essential functions of her job, any qualifying demand arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member or on covered active duty, or the employee could be paid 26 work weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness if the eligible employee is the service member's spouse, son, daughter, parent, or next of kin. We are proud of our veteran employees and are grateful to those who have served. We honor our veterans in many ways and celebrate them throughout the year here at XYZ. We have employees who are currently members of the armed forces, and as their manager, you need to understand their rights. Uniformed Services Employment and Reemployment Rights Act, or USERRA, protects civilian job rights and benefits for veterans and members of the active and reserve components of the U.S. Armed Forces. USERRA provides that returning service members must be promptly reemployed in the same position that they would have attained had they not been absent from military service, with the same seniority, status, and pay, as well as other rights and benefits. For example, if you have someone on your team that either has annual training or is called to active duty, they must be reemployed in the same position once they return from service. I understand this might make it difficult to manage production in our environment, and we have created a contingency plan to hire contracted workers during this period to fill the void. Sometimes the hardest part for managers is disciplining employees and even sometimes having to terminate them. We establish relationships with our colleagues, and these things can be extremely difficult. We in HR are here to help with this, and for the sake of our conversation today, please know that certain things should never enter the equation as we deal with misconduct, discipline, and terminations. Remember when we discussed the protected class earlier? Those same classes should never be considered when dealing with performance issues. Again, those consist of race, religion, color, sex, national origin, age, disability, or genetic information. Discipline and performance appraisals are heavily litigated, and these should be objectively aligned with the strategic goals of our organization. As a manager, it is important that you document and provide a record of outcomes in terms of quality, quantity, timeliness, cost effectiveness, need for supervision, interpersonal impact, or citizen performance, and finally, work performance. Performance should always be measured by a specified job function for a specific period of time. To help you stay on track, we have evaluation forms to use. Always ask HR if you have any questions on to be measured or when dealing with performance issues. We are here to help you. While XYZ is not currently affiliated with a union, this doesn't mean that we can interfere with the employees in their rights to form, join, or assist a labor organization. I understand some of you have been approached or have been members of a union previously. Whatever feelings you might have, please do not interfere with your employees' rights. Similarly, labor organizations may not interfere with employees in the exercise of these rights either. Please be sure to contact someone in HR if you hear of anything related to your employees and labor organizations. We do not expect you to work through these details, but rather want to make you aware of what not to do should you hear of this within your teams. Under the OSH law, we have a responsibility to provide a safe workplace. As a manager here, it's your responsibility to help maintain a workplace free from serious recognized hazards and comply with standards, rules, and regulations issued under the OSH Act, more commonly known as OSHA. We have signs, color codes, posters, and labels within our manufacturing area to warn employees of potential hazards. If an incident occurs, please notify someone immediately. You will also be required to attend mandatory training as per our company policy. The most common workplace injuries involve motor vehicles and falls or slips. Lower back injuries account for nearly 25% of lost workdays and cost over $30 billion a year nationwide. Aside from what this can cost our company, this can mean years of your life and the quality of life to your team members. So be safe and know the codes. In conclusion of today's training, please understand how important your role is within our organization and how critical your adherence to these policies is to our company's success. In summary, the main topics to remember are equal employment laws, managing an equal workforce, your role and how to handle the situation when you hear of someone's interest in joining a labor union, and finally, maintaining a safe workplace. I appreciate your time and attention today. Your manager handbooks outline these topics in case you need to refer back to our company policies. However, please let me know if I can answer any questions.